There are sectors of our economy that were promised that they would be exempt from the financial impacts of the Climate Commitment Act. Yet here we are, a year and a half into this thing, and those exemptions have not come to fruition. This segment is brought to you in partnership with our friends over at Future 42. Turn your frustration into action at future42.org. So we'll get to the farmers in a moment, but joining the farmers in feeling like they were either lied to, taken advantage of, or both is the trucking industry. The Washington Trucking Association has taken a similar stance to the farmers. Both of them were promised exemptions, meaning that the fuel cost increases from the CCA, they would not have to bear the burden of those. But here we are a year and a half later, and they are very much bearing the burden of those. And their efforts to try to get the state to comply with what's written into the law have not been successful. This from Fleet Owner, which is a publication that, as the name suggests, has to do with trucking issues. The headline, Washington climate legislation faces trucking backlash. Fuel used in agricultural transportation is supposed to be exempt from the program for the first 5 years. But after the legislation, fuel costs skyrocketed for fleets moving agricultural goods. Fuel suppliers introduced fuel surcharges in response to the act that did not exclude agricultural transportation. Brian Hildebrand, who's a safety compliance officer for refrigerated transportation companies in Washington, he said it inflated all of their costs. So not only were they not exempt, they're very much feeling the impacts of the financial burden of the CCA. It says after court shot down the Washington Trucking Association's petition for review of the act's execution, the trucking industry is looking to a November ballot to ease the strain of fuel suppliers' climate legislation surcharges. So the bottom line here is truckers, like in good faith in the trucking industry for the past year and a half, are kind of thinking, okay, the state will do what they're supposed to do under the CCA. We have an exemption of the first 5 years written in. The state's like, oh, we haven't figured out how to carry out this exemption. And they've been very patient. I would argue almost too patient in waiting for the state to put that exemption into action. And now they're done. Frankly, they're done waiting. And, their legal effort to try to get this taken care of wasn't successful. And so they're now hoping that the CCA is repealed because that's the only option that they've been left with. And we're now hearing similar sentiments from the Washington State Farm Bureau. Bree Elsey with the Washington State Farm Bureau joined us on Sundays with Subscribers yesterday. One of the reasons we had her on is almost exactly a year ago, we had her on the show, and the title of that show was Road to Exemption, where she talked about farmers trying to get this exemption that they were promised. And instead, what happened? The state's like, oh, give them $30 million and maybe they'll be quiet about it. And $30 million doesn't even begin to cover the loss associated for farmers who are having to pay these heightened fuel costs. And so Bree Elsey with the Farm Bureau said the same thing that the trucker said on our Sunday show. We've waited long enough, and now our only hope is that voters repeal the CCA in November.
The litigation wasn't to recover hundreds of millions of dollars. It was just to compel Ecology to open rulemaking to fix their broken program.
Right.
And so that's the question that was before the judge. Can we open up rulemaking and fix what is an obvious problem? And like you said, the legislature acknowledges last year, by allocating $30 million to agriculture and transporters, that there's a problem. Their intent by passing that bill was to exempt everyone. And obviously that didn't happen if in their mind there was at least tens of millions of dollars in damages. And so now what? We have this legislative acknowledgement, and now we have this court decision that allows Ecology to continue to be negligent and abdicate their duty under statute. And I think what's unfortunate is I think we see this a lot in the court systems. I think you see this a lot in the court systems. I know you're pretty engaged in different actions as well. Why is our court system an apologist for the agencies?
Yeah.
When you see Nigerian fraud and all of these things happening, yet everybody is remarkably unscathed.
Yeah.
Everybody has their jobs and nothing changes. And they are allowed to continue on with this behavior left relatively unchecked. And I think that's the big frustration here is this just happens time and time again.
So you said, what happens next? What does happen next? Are you guys appealing? Is it?
So that'll be up to the Washington Farm Bureau Legal Foundation.
Okay.
And there'll be several pathways presented to them. And there are appeal abilities. There's 30 days to decide whether or not an appeal is appropriate. And you could appeal directly to the Supreme Court. You could appeal to the Court of Appeals. But we know we have this outlier situation right now. We have this ballot or this initiative on the ballot. And so what do you do in light of something that's polling really well, but as we know in politics, can also change on a dime?
Yep.
So is this program even going to exist after November? It's hard to know.
So look, you guys know how I feel about all of this. At the very base level, regardless of how you feel about climate policy or Governor Inslee and climate policy, if they can't be honest about it, why do they deserve to keep it? I mean, that's kind of what I keep going back to. And we'll get to some of Governor Inslee's continued dishonesty on this coming up in Unbelievable. It's really wild. Some of the things that he's been saying about what will happen, like the sky will fall if we vote to repeal the CCA. But look, if Governor Inslee had owned the policy, said this will impact people, sorry about that, but I think it's the right policy. I'm not sure we're in this environment where you have farmers and truckers and a bunch of people revolting against the CCA. In the case of farmers and truckers, they just feel misled. They feel lied to. They don't feel like they were promised something. They were promised something. They were in the law promised an exemption. But a year and a half later, that exemption is nowhere to be found. They have every right in the world to be upset. I'm shocked that their legal efforts haven't been successful because, again, the law spells it out in black and white that they should get something that they're not getting. And so now they're throwing their hands up and they're just hoping that voters repeal the CCA with 2117 because a year and a half has gone by and they have no faith that if given more time, the state will do what it has promised to do. That segment is brought to you in partnership with our friends over at Future 42. Turn your frustration into action at future42.org.